President.
Let us pray. Almighty God, we willingly acknowledge you as the supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Oath or affirmation, announcements by the President.
Honorable Senators, I have granted leave of absence to Senator the Honorable Robert LaHunt, Senator the Honorable Dennis Moses, and Senator Hazel Thompson IE, all of whom are out of the country, and to Senator Anita Haynes, who is ill. Honorable Senators, I have received the following correspondence from Her Excellency the President Paula May Weeks, ORTT. The Constitution of the Republic of Trinidad and Tobago, by Her Excellency Paula May Weeks, ORTT, President of the Republic of Trinidad and Tobago and Commander-in-Chief of the Armed Forces. To Mr. Augustus Thomas, whereas Senator the Honorable Dennis Moses is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago. Now, therefore, I, Paula May Weeks, President as aforesaid, acting in accordance with the advice of the Prime Minister, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Augustus Thomas, to be temporarily a member of the Senate, with effect from the 29th of January 2019, and continuing during the absence from Trinidad and Tobago of the said Senator the Honorable Dennis Moses, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President St. Anne's this 28th day of January 2019. To Mr. Josh O.W. Drayton, whereas Senator Hazel Thompson IE is incapable of performing her duties as a senator by reason of her absence from Trinidad and Tobago. Now, therefore, I, Paula May Weeks, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(c) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Josh O.W. Drayton, to be temporarily a member of the Senate with effect from the 29th of January 2019 and continuing during the absence from Trinidad and Tobago of the said Senator Hazel Thompson IE, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President St. Anne's this 29th day of January 2019. Honorable Senators, I have to receive two further instruments, and I will, with your leave, revert later on in the proceedings to the swearing-in of those two temporary senators, but senators are now required to take the oath.
I, Augustus Thomas, having been appointed a member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago, upon which I am about to enter.
I, Josh Drayton, having been appointed a member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago, upon which I am about to enter.
Petitions. Petition lodged by the Attorney General on behalf of the Chief State Solicitor requesting the use of the Hansard in court proceedings.
Attorney General.
Madam President, I beg to present a petition on behalf of Kadeen Matthew, Attorney at Law for the Chief State Solicitor of Trinidad and Tobago, of number 23 to 27 St. Vincent Street, Port of Spain. I move that the clerk be allowed to read the petition.
Honourable Senators, is it agreed? Yes. Clerk, please proceed.
Your petitioner is the Attorney at Law on record for the Honourable Attorney General of Trinidad and Tobago, hereinafter called the respondent, in the High Court Action number 2726 of 2018, which matter concerns an application by Diane Jamili Hadid, hereinafter called the applicant, who is seeking inter alia a declaration that Section 15(1)(a) of the Legal Profession Act, Chapter 9003 of the laws of Trinidad and Tobago contravenes, is inconsistent with, infringes, and or abrogates the constitutional rights of the applicant enshrined in Sections 4A, B, and D of the Constitution of Trinidad and Tobago, to the extent that Section 15(1)(a) applies to and confers a benefit to nationals of Trinidad and Tobago only, and has the effect of depriving the applicant by reason of her origin of the rights enshrined in Sections 4A, B, and D, and accordingly is null, void, and of no effect. An affidavit sworn to on 25th July 2018 and filed on 26 July 2018 by the applicant, hereinafter referred to as the said affidavit, stated that the applicant is desirous of being admitted to practice and enrolled as an attorney at law of the Supreme Court of Judicature of Trinidad and Tobago, and has taken all the required steps towards being admitted to practice pursuant to Section 15(1)(a) of the Legal Profession Act, Chapter 9003. However, her application has been denied solely on the basis of her nationality. The applicant deposed that she was a holder of a Grenadian birth certificate, St. Lucian citizenship, and a St. Lucian passport, and on 7th April 2017, she was granted a certificate of recognition of Caribbean Community Skills Qualification by the Government of Trinidad and Tobago. On 1st December 2017, the applicant completed the 6-month attachment at Montano and Company. The applicant further deposed that on 29th March 2018 and 10th April 2018, the Registrar of the Supreme Court of Judicature of Trinidad and Tobago, hereinafter called the Registrar, stated that the applicant was ineligible to be admitted to practice law pursuant to Section 15(1)(a) of the Legal Profession Act, Chapter 9003, unless she shows proof of Trinidad and Tobago nationality. The applicant stated that by letter dated 13th April 2018, the LATT informed her that her application did not meet the qualifications for a certificate of fitness as she was not a national of Trinidad and Tobago. The applicant deposed that she has been advised by counsel and verily believes that she should not be subjected to any restriction on her right to engage in any gainful employment or occupation that does not apply to Trinidad and Tobago nationals, and the effect of Section 15(1)(a) is to impose a restriction on gainful employment solely on the basis of nationality. By order dated 4th December 2018, the Honorable Mr. Justice Kokaram granted permission to the defendant to file affidavits in response on or before 31st January 2019. The Hansard Report of Proceedings of the Senate for the 5th October 2000 should be produced and referred to at the hearing of the constitutional motion before the High Court to indicate what took place in the Senate on the said date in relation to the passing of the Legal Profession Amendment Act 2000, Act number 76 of 2000. The Clerk of the Senate acting or other such officer responsible for the making of the Hansard Report in the Senate should swear to an affidavit referring to and exhibiting the said Hansard Report of the proceedings or extracts thereof, and attest that they are the true record of what was said in the Senate on the said date. The petitioner thereof humbly prays that the Senate do grant leave for the Clerk of the Senate acting or other such officer to swear an affidavit referring to and exhibiting the Hansard Report to attend the hearing before the Honorable Judge if required. And your petitioner in duty bound will ever pray, dated this 16th day of January 2019, for the Chief State Solicitor.
Honourable Senators, the question is that the petitioner be granted leave to proceed. All in favour say aye. Aye. Any against? The ayes have it. Leave is granted.
Papers.
Minister in the Ministry of Finance.
Thank you, Madam President. Madam President, I have the honour to lay on the table the following papers as listed on the order paper and supplemental order paper in the name of the Minister of Finance. The ministerial response of the Ministry of Finance to the interim report of the Public Administration and Appropriations Committee, 3rd session, 2017-2018, 11th Parliament, on the processing of payments of pensions and gratuity to retired public officers and contracted employees. The annual report of the Financial Intelligence Unit of Trinidad and Tobago for the year ended September 30, 2018. The ministerial response of the Ministry of Finance to the 14th report of the Public Accounts Enterprises Committee, 3rd session, 2017-2018, 11th Parliament, on an examination of the audited accounts, balance sheets, and other financial statements of the National Commission for Self-Help Limited for the financial years 2008 to 2015. And the reports of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Samoa-Laventil Regional Corporation for the years ended September 30, 2011 and 2012. Thank you, Madam President.
Minister of Agriculture, Land and Fisheries.
Madam President, I have the honour to lay on the table the following papers listed on the supplemental order paper in my name. The Land Acquisition Requisition Order 2018. I thank you.
Government Business.
Thank you very much, Madam President. Madam President, I have the honour to lay on the table the following papers as listed on the order paper and the supplemental order paper in the names of the Attorney General, the Minister of Planning and Development, and the Minister of National Security. The Criminal Procedure, Plea Discussion and Plea Agreements, Amendment to Schedule Order 2018. The ministerial response of the Ministry of Planning and Development to the 8th report of the Joint Select Committee on Human Rights, Equality and Diversity, 3rd session 2017-2018, 11 Parliament, on an examination of the perceived inequality faced by single fathers in Trinidad and Tobago, with specific focus on custody matters, policies, and access to programs and services. And finally, the annual administrative report of the Ministry of National Security for the period October 2014 to September 2015 and October 2015 to September 2016.
Reports from committees.
Senator Mark.
Thank you, Madam President. I have the honor to present the following report as listed on the supplemental order paper in my name. The 16th report of the Public Administration and Appropriations Committee, 3rd session, 2017-2018, 11th Parliament, on an examination into the implementation of the public sector investment program.
Urgent questions.
Senator Mark.
Thank you, Madam President. To the Honorable Attorney General, in light of the United States Embassy's request that all prospective applicants for U.S. visas must possess computer-generated birth certificates, can the Attorney General advise as to what is the state of readiness to deal with this matter?
Attorney General.
Thank you, Madam President. Madam President, there's a material error in the question. The U.S. Embassy's publication is not that all visas are required to have these polymer certificates. They are specifically limited only to immigrant visas, which are very few in number. I'm able to say that the Registrar General's Department has, in fact, been issuing polymer certificates since February 2016. We're well ahead of that curve. Persons can apply for and obtain the certificate on the same day of the application at the department's head office at Port of Spain or any of its sub-offices at San Fernando, Arima, and Tobago. Applicants can also apply for birth certificates via the department's online service at the Ministry of Legal Affairs website. However, an applicant who uses this service will have to come in and pay for the requisite fee to collect the certificate. In the circumstances, we are well ready, but this issue of the United States position is limited only to immigrant visas and not the regular visas for tourist travel.
Next question, Senator Mark.
To the Honorable Minister of Energy and Energy Industries. In light of the United States government's decision to impose sanctions on the Venezuelan oil company, Petrolero de Venezuela S.A. PDVSA, can the minister state what impact this decision is likely to have on the recently concluded Dragon gas deal?
Minister of National Security.
Thank you very much, Madam President. Madam President, the recent sanctions imposed by the United States of America on PDVSA are currently the subject of advice. We are seeking advice with respect to same to understand exactly how it may, and I emphasize the word may because as the sanctions themselves say, they start off by saying how they may affect certain things, how they may affect the Dragon deal. So we're currently awaiting advice. So it is very premature at this stage to say what, if any, effects it may have.
Senator Mark.
Can the minister indicate to the Senate whether the government of Trinidad and Tobago intends to hold discussions with the government of the United States on this entire matter of the Dragon gas deal?
Senator Mark, that question does not arise. Next question. Next question, Senator Mark.
To the Minister of National Security. In light of the recent closure of the Cedros port due to an overflowing cesspit, can the minister inform the Senate what measures are being taken to rectify this problem?
Minister of National Security.
Thank you very much, Madam President. Madam President, this situation is currently attracting the attention. The Ministry of National Security has requested the expert assistance of the Ministry of Works and Transport and asked that their engineers visit the particular location, do an assessment, and then come back to us telling us what they have found. Unfortunately, it was someone from the regional corporation who decided to make an issue of it. But we've asked the Ministry of Works to take a look at it and to get back to us.
Senator Mark.
Madam President, can the Honourable Minister indicate to this House what impact this temporary closure will have on the inflow of persons from Venezuela, including citizens of our republic?
Minister of National Security.
Madam President, what it meant is that yesterday when it was shut by the immigration and other officers, it houses Immigration, Customs and the Police Service at the Port of Cedros. When it was shut, they were not able to take any inflow of persons entering through that legal port of entry. So until it is reopened, persons cannot come in through that legal port of entry.
Senator Mark.
Can the Honourable Minister indicate what time frame he anticipates for the reopening of that port?
Minister of National Security.
Not at this stage, ma'am. As I said earlier, we're currently awaiting an assessment and recommendations from the engineers and experts from the Ministry of Works and Transport.
Next question.
The Honourable Minister of Finance. Can the Minister advise as to when the Board of Inland Revenue will be implementing the increase in the exemption on stamp duties for first-time homeowners as passed in the 2019 budget?
Minister in the Ministry of Finance.
Thank you, Madam President. Madam President, we have been advised by the Chairman of the Board of Inland Revenue that they will be in a position to start granting the said relief by January 21st of this year.
Can I ask through you, Madam President, persons who have applied and have not been successful, would they be entitled to retroactive payment on their stamp duties?
Minister.
That's what you mean. Senator Mark, I've spoken to the PS who has spoken to the chair about providing for refunds to the people who would have overpaid stamp duty on these first-time purchases.
Okay. Next question, Senator Obika.
Thank you, Madam President. To the Minister of Education, in light of Twitter's legal action in respect of school-based assessments, can the Minister advise as to what impact, if any, this action is having on the students?
Minister of Education.
Madam President, the Ministry of Education has not received any reports that students have been adversely affected by Twitter's action with respect to SBAs. Thank you.
Senator Wika.
Thank you very much, Madam President. Given the Minister's response, is it that we should take lightly the reports by Twitter's president that they are looking seriously at the fact that the Jamaican government pays their teachers for marking SBAs and not Trinidad and Tobago government?
Okay, that question does not arise. You have one more question if you wish to ask.
Could the Honourable Minister indicate if they will be addressing payment of SBAs to teachers in Trinidad and Tobago?
That question also does not arise, Senator Obika.
Questions on notice, questions for oral answer.
Leader of Government Business.
Thank you very much, Madam President. Madam President, the government is pleased to announce that it will be answering all questions on the order paper listed today.
Senator Mark.
Question number 39 to the Minister of National Security.
Minister of National Security.
Thank you very much, Madam President. Madam President, over the period January 1st, 2014 to present, a total of 169 persons were killed following confrontations with officers of the Trinidad and Tobago Police Service.
Can the Honourable Minister indicate whether the government intends to conduct any official coroner inquiry or inquest into the deaths of these, did I hear him right, Madam President, 169 deaths of persons at the hands of the police?
Minister.
Thank you very much, Madam President. Madam President, I would have thought as an experienced legislator, one would know that it is not for the government to call upon the conduct of the coroner's inquiries. Coroner's inquiries are being conducted. I believe my friend, Senator Mark, has a follow-up question, number 14, that deals specifically with coroner's inquiries.
Senator Mark.
Okay.
Next question.
Question number 40 to the Minister of National Security.
Minister of National Security.
Thank you very much, Madam President. Madam President, the answer to question number 40 is during the year 2017, 3 fatal police shootings were forwarded for a coroner's inquest. 2 from the Southern Division and 1 from the Professional Standards Bureau. Furthermore, for the period January 1st, 2018 to present, 2 fatal police shootings were forwarded by the PSB, the Professional Standards Bureau, for coroner's inquest.
Madam President, can I ask through you to the Honourable Minister what urgent steps are being taken by the Ministry of National Security to provide police officers with alternative instruments or devices when confronted by, let's say, citizens, rather than using, let's say, force that could result in the death of citizens. For example, taser, pepper spray, etc.
Senator Mark, that question does not arise from the question asked or the answer given. Any further supplementary questions? Next question, Senator Mark.
Question number 47 to the Minister of Works and Transport.
Minister of Works and Transport.
Thank you. Thank you, Madam President. Madam President, the question on the Currep interchange, part 1, has there been agreement between the government and all the homeowners? Madam President, there are 10 homeowners who have to be relocated. Government has reached agreement with 9 of them. The agreement for the final homeowner is being finalized. However, that property is not critical to the project at this stage. Part 2, how many families? 10 families have to be relocated. Part 3, cost of the relocation. Madam President, negotiations continue. So at this time, there's no final figure. And the project date have been, the final date for the project have been rescheduled to December 2019. Thank you.
Senator Mark.
Madam President, could the Minister indicate what was the nature of the agreement arrived at between the 9 homeowners and the Ministry of Works and Transport?
Minister.
Thank you, Madam President. Madam President, the 9 homeowners have agreed to accept the Commissioner valuation offer of 80% of the value while negotiations continue and give vacant possession of the land. Thank you.
Senator Mark.
Can you advise this House whether the owners of K-Donna have been paid at this time for their property? The owners of K-Donna?
Senator Mark, that question does not arise. I think I'm seeing the question asked about homeowners.
Well, I think that's the homeowner as well. The people of K-Donna people who own the property.
Question, Senator Mark. Senator Mark. Senator Mark, no, please take your seat. So your supplementary question was not allowed. Do you have any further questions to ask? Yes?
Can the Honourable Minister advise this House whether any part payment has been made to the 9 homeowners in which agreements have been arrived at? Madam President?
Minister of Works and Transport.
Madam President, the agreement have been arrived at. Some owners, my information is that the checks are being prepared, have started to be prepared over a week ago. I can't say at this time if any of them have collected their checks or if that process have been completed. But the process have started and no check was paid to any of the other landowners, including Kedona. Thank you.
Is the Minister, through you, Madam President, in a position to share with this House what is the value of those checks that have been processed but are yet to be distributed to the homeowners where there has been agreement thus far?
Minister?
It would be very irresponsible of me as a minister to come to the Parliament and call the figures that is being paid to homeowners at this point in time. But I can say the commissioner valuation would have put a valuation and the homeowners would have accepted 80% of that value. I am not going to be responsible to say what is the value that each homeowner is getting. Thank you.
Senator Mark, you have no more questions on this one. Next question, Senator Mark.
Question number 61 to the Minister of Energy and Energy Industries.
Minister of Energy and Energy Industries.
Thank you very much, Madam President. Madam President, as I've stated on many occasions in this Parliament and outside of this Parliament, the decision to close the refinery was based on evaluation of the business model under which Petrotrin operated. In all scenarios developed by the Board of Directors, the refinery sustained substantial losses and more importantly, eroded gains achieved by the exploration and production side of the business. HSB Solomon and Associates activities comprise a workforce optimization study, an exploration and production benchmarking exercise, and other professional services. McKinsey and Company did not produce any specific reports. McKinsey and Company was engaged as industry experts to assist the board to understand and design solutions to the continuously deteriorating operations of Petrotrin. This was done in incremental work streams that involved experienced Petrotrin subject matter employees working in a team together with the consultants. McKinsey engagement covered several modules. These are strategic review, review of upstream and downstream operations, and the current transition phase. The activities conducted by McKinsey and Solomon were important in assisting the board to understand the business, but were part of a number of factors that led to the decision to close the refinery. For this reason, there is no specific report on the closure to lay in this Parliament.
Senator Mark.
Can I ask through you whether the Minister is prepared to lay in this Parliament the several modules that were devised by McKinsey?
Minister.
Madam President, the modules was derived in consultation. Sometimes they are written, sometimes they are slide presentation, but it was part of a holistic process of looking at the companies, its weaknesses, its strengths, and the restructuring exercise. There are no specific reports to lay in Parliament.
Senator Mark.
Would the Minister be prepared to provide this Parliament with the written and slide presentations delivered by McKinsey on this whole question of Petrotrin?
Minister.
Madam President, it has been said on many occasions here that McKinsey didn't specifically recommend a closure of the refinery. McKinsey was involved together with Petrotrin's management at the time to evaluate the company, its strength and its weaknesses. And I want to repeat, there is no specific report to lay in this ballot.
Senator Mark.
Can the Honourable Minister provide us with some specimens or some answers as it relates to the design solutions that were advised or advanced by McKinsey during this whole strategic review exercise of Petrotrin? Can he provide us with some elements of those design solutions, Madam President, as advanced by the Honourable Minister?
Minister.
Madam President, the design solution is now in the public domain. Trinidad Petroleum Holding Company as a holding company. Paria Trading and Terminaling Operations. Heritage Exploration and Production. And Petrotrin, which is a legacy company, to hold the historical legacy matters that Petrotrin will have to continue to address for several years.
No, you have one more. And?
Can the Minister indicate, since he spoke about Paria as one of those companies, is the Minister aware that the last shipment of our crude oil, which was transported by a company called BW Eagle, was taken to the St. Croix refinery in the U.S. Virgin Islands for refining purposes? Is the Minister aware, using the Paria Oil Company?
Senator Mark, that question does not arise. Next question, I believe, Senator Mark, you're asking it on behalf of Senator Haynes?
Yeah, I asked this question on behalf of Senator Anita Haynes, Madam President. And that is question number 101.
Senator Mark? My apologies. The next question is question number 62.
Oh, I myself was advanced of myself. Thank you very much, ma'am. Yes, to the Honourable, question number 62 to the Honourable Minister of Energy and Energy Industries.
Minister of Energy and Energy Industries.
Thank you very much, Madam President. Madam President, the Minerals Division of the Ministry of Energy and Energy Industries is currently staffed by 21 technical officers on the permanent establishment, 20 daily paid employees, and 10 quarry management officers on contract. There are 9 vacant offices comprising of 4 geologists, 3 mining inspectors, and 1 geoscience surveyor, 1-2, and 1 draftsman, 1, and 1 draftsman, 2. The Ministry of Energy and Energy Industries is working assiduously with the Service Commission Department to ensure that these vacancies are filled in the shortest time frame. In addition, it is envisaged that in the first quarter of calendar year 2019, the Ministry will finalize its phase 2 of its restructuring exercise. This exercise is intended to assess and determine the human resource needs of each division to ensure alignment with its mandate. The Minerals Division is an integral part of this process.
Madam President, in light of what we have been advised, can the Minister indicate what kind of time frame would be required to, first of all, well, I should say, fill those vacancies identified by the Honourable Minister?
Minister.
Madam President, as everybody who operates in the public service is aware, the recruitment process in the public service falls under the ambit of the Service Commission. The Ministry, the Minister, nor the PSs have absolutely no say in that recruitment process, and we have been working very closely with the Service Commission, but historically, the Service Commission, I make no apologies for this statement, has been a slow-moving wheel, and we are working with them to see how fast they can accelerate this recruitment exercise.
Senator Ramdeen.
Thank you, Madam President. Madam President, through you to the Honourable Minister of Energy and Energy Industries. Minister, having regard to the answer that you've given with respect to the staff at the Mineral Division, how has this shortage of staff affected the ability of the Ministry to monitor the illegal quarrying that takes place?
Minister.
Thank you very much, Senator Ramdeen, for that question. Madam President, as is publicly known, we do have serious concerns about illegal quarrying in Trinidad. Illegal quarrying largely occurs in northeastern Trinidad on state land. We are now initiating a coordinated multi-agency approach, which involves the Commissioner of State Lands, the Director of Minerals, and the Commissioner of Police. And we have established operational and investigative SOPs in conjunction with the Office of the DPP to have a coordinated effort, and we hope to strike soon.
Senator Mark.
Can the Honourable Minister indicate to this Senate how has the vacancies impacted on this division issuance of licenses to scores of legitimate quarry owners who have been seeking proper licensing from the Ministry of Energy and Energy Industries?
Minister.
Madam President, Senator Mark has hit another important question. What is happening with the renewal of licenses is that the Minerals Act was revised in 2015, and the new act and its regulation has made very specific requirements to be granted a license. Most of the old quarry operators did not comply before, but now to get their license renewed, they have to have a series of statutory approvals, including EMA, included water extraction permits from WASA, and a whole myriad of fundamental documents that they need to provide. That is taking some time. They think it's a hindrance, but as a modern society that has to deal with the extractive industry, we do not think so. So the process has been slow, but we are trying to impress on the quote-unquote legitimate quarry operators that they have to comply with the new act.
Senator Ma.
Madam President, in light of the existence, as the Minister has advanced, of a multi-agency task force to deal with the illegal quarrying situation, can the Minister advise us on the House whether the government intends to introduce specific legislation to deal with criminality in the illegal quarrying business in Trinidad and Tobago that currently does not exist under the legislation that governs this particular area of operation?
Minister.
Madam President, the Ministry of Energy and Energy Industry has no intention to create specific legislation to deal with any form of criminality. Criminality is a function of the Ministry of National Security and the Police Service. We will work closely with the Police Service to implement and to bring a reduction in the proliferation of illegal quarrying in Trinidad and Tobago.
No, you can ask. You have one more.
Is the Minister aware, through you, Madam President, that there has been languishing at the Legislative Review Committee for some time now, legislation to upgrade and enhance the whole question about supervision and regulation of the quarrying industry? Are you aware of such legislation? And if you are, can you tell the Senate when?
Questions, eh?
Well, whether he's aware and...
Well, no, whether he's aware. Minister.
I am very much aware, and the chairman of the Legislative Review Committee, Senator Rambarat, is also aware.
Next question, Senator Mark.
Yes, as you advised, Madam President, I asked this question on behalf of our colleague, Senator Anita Haynes. Question number 101 to the Minister of National Security.
Minister of National Security.
Thank you very much, Madam President. Madam President, the Trinidad and Tobago Police Service currently has 377 non-operational vehicles. During 2019, the Trinidad and Tobago Police Service plans to conduct a thorough and comprehensive assessment of approximately 200 non-operational vehicles to determine whether the vehicles will be disposed of or refurbished. Vehicles are disposed of once they are no longer feasible to maintain, and that determination is based on factors such as cost, age, and state of disrepair.
Yeah, okay.
Introduction of bills. On the supplemental order paper, 1. The Evidence Amendment Bill 2019 in the name of the Attorney General. And 2. The Sexual Offences Amendment Bill 2019 in the name of the Attorney General. Public business, government business, bills second reading.
Attorney General.
Thank you, Madam President. Madam President, I beg to move that a bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011 be now read a second time. Madam President, it gives me great pleasure to continue what is the very important work of the people of Trinidad and Tobago as identified by not just the government, but by all of us citizens of Trinidad and Tobago. Crime remains the #1 issue in our economy. The battle against crime is directly related to the population having confidence that there is a result to be applied in stamping out crime. The very haggard statement of committing a crime and doing the time seems to be something which doesn't apply in Trinidad and Tobago if one looks at the history of the criminal justice system's operation. Trinidad and Tobago has been grappling with the issue of preliminary inquiries for a number of years. Indeed, preliminary inquiries as a feature of our law started by an Act of Parliament in 1917. And when we look to the laws of Trinidad and Tobago, and we start off with that important law, the Indictable Offences Preliminary Inquiry Act, Chapter 1201, that's an Act of Parliament number 12 of the year 1917. That act has been amended 26 times in the course of its history. 21 of them in large part intended to tweak the law, and on a couple of the occasions, 5 of them in attempts to actually repeal and replace law. And the question for us right now is, what are we intended to do with these mere 30 clauses? It's necessary for us to have a little bit of a recap as to what this law is about. What is a preliminary inquiry? What is it intended to do? Where does it fit within the architecture of the criminal justice system? What does that criminal justice system look like statistically for us in Trinidad and Tobago, so we know what we're dealing with in terms of Trinidad and Tobago and not elsewhere? How does the amendment fit within the structure of reform? And then how do we operationalize it? And I expect today that there may be unanimity of purpose on the legislative aim from what I've looked at, but I feel that the real debate goes to the operationalization. And therefore, I confess immediately that in piloting a bill of this type, I may not be able to do immediate justice to that which is to be said on operationalization, but at the wrap-up, I'm certain that I'll be able to answer questions raised, because one has the obligation to present the bill, to lay the proportionality and make it survive constitutional consideration, and then one has the obligation to speak to the operationalization of the law. So let's dive into this. Preliminary inquiries are a feature of our English common law, or English inherited law, birthed in the year 1555 by the Marian Committal Statutes, a mere 464 years ago. In 1836, we had the Prisoners' Council Act, 183 years ago. In 1848, we had the Indictable Offences Act, the Sir John Gervais Act, 171 years ago, that applied in our jurisdiction. In 1917, of course, 102 years ago, we had the Preliminary Inquiries Act, Chapter 1201. In 2005, some 14 years ago, we made some improvements to the criminal arena, the preliminary inquiries arena, by taking account of what we call paper committals. In 2011, 8 years ago, we had the law which we now seek to amend come to the Parliament. We are dealing with Act number 20 of 2011. Today, we come to amend that law 8 years later. In 2012, we had a repeal of that 2011 law, where we dealt with the very infamous Section 34 proclamation and having to reverse it. In 2014, we adjusted gears as a country. We moved to something called committal proceedings in an attempt to remove indictable proceedings. In 2017, we as a Senate, some of us, indeed Senators Choate and Senators Richard in particular on the independent bench, and my colleagues on the opposition bench, we sat and we considered a new formulation to treat with indictable route and how we deal with preliminary inquiries. We took away the learning and experience from that and then came back to this bill in circumstances which I will explain in a moment. So what's a preliminary inquiry? A preliminary inquiry ideally has two specific purposes. It's in effect, in one large sense, a filtration mechanism to ensure that a case is being properly put for an accused to answer. Obviously, that dual purpose is to allow the accused person to be aware of the case, on the one hand, and then secondly, to give him an opportunity to probe and counter that case. Preliminary inquiries run alongside this criminal justice system. What is the criminal justice system? We have the courts, the magistrates' court, the high court, the assizes, being the High Court, the Court of Appeal, and then the Privy Council. We have the actors and players in the courts. We have the prosecutors, the defense attorneys, the judges, the witnesses, the prisons management, the ancillary staff. We have, of course, the accused and the victim. We have this mechanism going to work in prosecutorial arms at the DPP's office and also in the Commissioner of Police. The DPP does 5% of the prosecutions in Trinidad and Tobago, and the Trinidad and Tobago Police Service, pursuant to the Police Service Act, they conduct 95% of prosecutions. So before we go into the bill, let's dive into some of the statistics. What is Trinidad and Tobago? What do we look like? What are our statistics? What have we been doing in our system of justice? I can tell you this. In our arena, of course, we have 46 magistrates, 12 magisterial districts. We have the Supreme Court with 13 justices of appeal, 35 puisne judges, 14 masters. We have since amended laws to increase those numbers. For instance, at the bench in the High Court, up by 77%. We've taken those to 64. In the appellate division, from 12 to 15. But what does our backlog look like? In the criminal justice arena, we're treating with a caseload at the magistracy and also at the Supreme Court. The Supreme Court is the High Court and the Court of Appeal. This is what we look like, Madam President. The statistics on criminal matters pending as at December 11th, 2018, at the magistracy and at the Supreme Court. Let's look first at the Supreme Court. As at that date, December 11th, 2018, 2,581 cases are pending. Sexual offenses, 470. Murder, 327. Offenses against the person, 497. Manslaughter, 25. Attempted murder, 111. Firearms, 235. Dangerous drugs, 119. Other indictables, criminal offenses such as larceny, fraud, kidnapping, 797. But listen to this. In the subcategories, if you take it by the number of years that matters are pending at the High Court, There are 149 cases of the 470 which are pending for over 10 years in the High Court. For murder, there are 84 cases pending for over 10 years. Offenses against the person, 219 cases of 497 pending for over 10 years. Firearms, 131 out of 235 pending for over 10 years. Let's go to the Magistrates' Court, where the bulk of matters happen. For the period ending July 31st, 2018, the matters that are pending at the magistracy, hear this number, 43,109 cases are pending. Of that, if we look to murder, in the period above 10 years at the Magistrates' Court, meaning they have not yet gone to the High Court, we have 584 cases pending. Attempted murder, 255. Kidnapping, 394. Arms and ammunition, 6,746. Sexual offenses, 2,915. Narcotics, 5,596. Fraud, 5,957. Larceny, 4,188. But let's put this into the human context. In the bulk of matters above the category of sexual offenses, we have above 5 years, 184 plus 108 plus 45 plus 13 plus 2 plus 17 plus 6 plus 3 plus 2. Those are the number of cases in each year above 5 years. Imagine someone waiting with 24 matters above 14 years of age for sexual offenses. That is victim, that is perpetrator, so alleged, that is juror, that is judge, traipsing up and down in our courts for 14 plus years to relive a sexual offense encounter. Now, these are all in the context of preliminary inquiries. Our preliminary inquiries law says that you have to have a preliminary inquiry. You go before a magistrate. The magistrate looks to see whether there is sufficient evidence to either bring you forward for a trial at the High Court or discharge you. The DPP has a power under Section 23 of the existing law to recommend an indictment in certain circumstances without a preliminary inquiry. But we have in Trinidad and Tobago, and if I take, without going into the case itself, I take the example of the Piarco Airport matter, simply to say that the allegations arising in that matter arose in the period 1995 to the year 2000. We stand in 2019, in the month of January, and suffice it to say that the preliminary inquiries into those matters are still going on. From allegations in the year 2000, in 1995, 1997 to the year 2000, the allegations are still being tested in preliminary inquiry in the year 2019. And in other jurisdictions where this matter has been dealt with, pleas of guilt were entered, people served time, they forfeited millions of dollars of assets, Trinidad and Tobago repatriated, and in fact, I'm pleased to announce today that as a result of an appellate ruling in the United States of America, Trinidad and Tobago, having picked up a case which was going nowhere under my predecessor, we have secured millions of dollars US in benefit for Trinidad and Tobago coming out of these matters in the United States. And I'll give the particulars of that in just a little while. So, Madam President, in our country, sexual offenses, fraud, people have a right to either be acquitted or, if accused, stand trial and, in fact, serve their time. But that's not the case in our jurisdiction. Now, is this government the first government to come up with the idea of improving preliminary inquiry route? No, we're not the first. In the United Kingdom, there's been a clear course of effort coming through the 1998 laws to the 2001 and 2003 laws and the PACE reforms and the crime and other package amendments that they produced in the United Kingdom. But right here in Trinidad and Tobago, in 2005, when we dealt with improvements to the law, in the year 2011, when we birthed this act, in 2014, when we dealt with it, we have had the experience of being in analysis paralysis. Let's discuss, let's tweak some more, let's manage the situation a little bit better, but it results in statistical information of the type that I have just put onto the Hansard record. 43,000 plus cases in arrears in the magistracy and 2,900 odd plus in the High Court. The definition of insanity is to expect a different result while engaging in the same activity on a continuous basis. So the government has come forward today. The government has said, let's come to amending the 2011 law. Why do we say that? We say that because whilst we came to the Parliament in 2017, whilst we engaged in debate in this Senate, whilst I piloted and dealt with law coming down to the month of September as well, in that exercise of considering a different route, because we came to the Parliament with the route that recommended that we allow the Director of Public Prosecutions the authority to say whether you're going to the High Court straight away or you're going to the Magistrates' Court. We did so on the back of the Constitution of the Republic of Trinidad and Tobago, the supreme law so declared by Section 2 of the Constitution, which allows in Section 90 the Director of Public Prosecutions 3 aspects of power. 1, to commence any prosecution. 2, to take over any prosecution. And 3, to end any prosecution. That was deemed to be a little too novel. People were concerned about the DPP's involvement. We went back to the drafting aspects, but while we were drafting and consulting in the period since last we were there, we were busy operationalizing the court systems. This Senate participated in the birthing of the Family and Children Division. We participated in the operationalization, which is imminent, in respect of moving 102,000 cases per year from the magistracy into traffic violations. You have 146,000 cases every year. We're moving 102,000 of them out. We created the Criminal Division and Traffic Division. We have proclaimed that Criminal Division. We're about to adjust a small aspect of that at the cabinet level. We have introduced the Criminal Proceedings rules. We have already approved the Public Defenders Division. We're out for advertisements on that. We've increased the judicial capacity by 77%. They are shopping for that arena of Commonwealth judges as we speak. We've introduced plea bargaining, bail only. We've introduced access to justice provisions. We have been busy operationalizing, but very importantly, we birthed new courts for the first time in this country. We appointed criminal masters, and we put in criminal proceedings rules. That therefore left obvious an alternate route for operationalizing this law. Whilst we were consulting, we were busy operationalizing, and we came forward to the 2011 Act, number 20 of 2011, the Administration of Justice Indictable Proceedings Act. We took what we had learned from our research and consultation, we applied it into the Act, and we come forward with these 30 clauses in this bill to ask the Senate to consider an improvement to the law in very material areas of closing gaps in the 2011 legislation, which we have had the benefit of considering. So whilst we were developing law, we were busy operationalizing law, and we were operationalizing law so we could have an immediate start. So let's dive into the bill. This bill, in its 30 clauses, and I have asked, I thought it courteous to provide a consolidated, marked up version of the bill for every senator. This is not a usual feature of any government. We have been consistent in my tenure as Attorney General to provide the Parliament with this information, and I have provided it for all senators so you can read the amendments in the context of the law that we're fixing. Secondly, we have circulated what the flow chart of it in its operation looks like, so that you can understand what the indictable only route is, the triable either way route is, the summary charges which accompany look like, and how they ought to flow. And we have done this to ensure that members have a better understanding of how the law is intended to be applied once operationalized. So let's dive quickly in the short time that one has to pilot this bill into what we're looking at in the amendments. We propose in clauses 1 and 2 the usual standard. Clause 1 is the short title of the bill. Clause 2, we're dealing with an act means the 2011 Act. Clause 3 is the interpretation section. In the interpretation section, we're adding in some very important features that were not present in the 2011 law. They are, firstly, a definition of what is an arrest warrant. Throughout the 2011 law, there was confusion between search warranting and arrest warranting, and we thought it prudent to define arrest warrants. We've dealt with the understanding of what documentary exhibit is, very importantly adding in photographic evidence, computer printout, and other document. Why? Because we intend to treat with what would otherwise be massive number of things for the police to manage or the courts to manage by way of documentary evidence for photographs, so we can return them, we can dispose of them, but we can catalog them without having, as a question in the Parliament earlier had, hundreds of motor vehicles impounded for years, rotting, when you simply need a photograph so certified as the evidence of the thing which was stolen or managed in a particular way. Very importantly, we've identified what an either-way offense is. And we've done that by reference to, obviously, an offense which is triable either indictably or summarily. And we've also referenced it to a schedule of offenses so that we can know what the either-way route is. In the 2011 law, there was a little bit of confusion at the point of start. In the 2011 law, we ought to have gone a little bit further by saying what happens at the point of first contact with the court. When you have that first contact, what about the nature of the matters? For the non-lawyers listening, when you are charged, you may have an indictable offense, meaning it's a serious offense. It must be dealt with by the High Court. You can have a summary offense, which can be treated exclusively by a magistrate. Then you have a category or species of offenses called a triable either way. It can either be indictable, it can either be summary, in which case you have to decide which court are you going to. And in this law, we've proposed that the Director of Public Prosecutions, the prosecutor, it may include a police prosecutor, has the election to say which way you're going to go. Obviously, the DPP has his constitutional intervention powers in Section 90 of the Constitution, and he can obviously have an input into that. Indictable offense we've defined. We've included a definition for an interpreter, for a keeper. We've harmonized the keeper meaning with 3 particular laws: the Summary Courts Act, the Indictable Offences Committal Proceedings Act, the Extradition and Commonwealth Foreign Territories Act, Chapter 1204. We've added in a prosecutor because we've taken note of the vigor of the current Commissioner of Police. He, having accepted that prosecutorial reform in the police is required, he having announced quite commendably a view which the government shares, and we're grateful, that the police prosecution route has to be amplified and bettered. We have included as a prosecutor not only the DPP's department or lawyers, but prosecutors in the meaning to be ascribed at the Police Service Act, Chapter 1501, where a police officer has the power to prosecute a person who commits any offense. And I'm very pleased to observe that the Commissioner of Police has announced a particular marriage of divisions under a financial investigation division, which is the marriage of the Anti-Corruption Investigation Bureau, the Fraud Squad, the Cybercrime Unit, and the Financial Investigation Branch, as financial crimes lay themselves as a solution to the scourge of criminality. Why? The government's agenda, shared obviously by the rest of the thinking world, is follow the money. We don't need Al Capone's experience to tell us that you can take you down for tax evasion if I can't catch you for murder. And this Senate has participated in umpteen amendments to money laundering, proceeds of crime, and income tax amendments to allow that follow the money, as civil asset forfeiture, explain your wealth, and registration of title and trust legislation will come to this Parliament almost imminently. We go further, we define search warrant. Let's jump straight to Clause 4 of the bill, which treats with Section 5 of the Act. We have very importantly adjusted the concept of believing to suspecting. And we say a master who is satisfied by proof on oath that there is reasonable ground for suspecting as opposed to believing that there is in any building, ship, vessel, box, receptacle, computer, or electronic device, anything, then you can have a warrant, you can seize, you can search and seize, and then you can have it reported to a master. This amendment to Section 5 via Clause 4 has some dynamite provisions in it. Number one, you store data in computers. A computer is a device including your phone. Much of the warranting evidence that we have managed to secure, which is evidence of criminality, we have found on computer bases. And therefore, it is necessary to speak in a positive sense so that we can capture the widest possible range of evidence. Importantly, when you search and seize, you seize it and report it to a master issuing the warrant or another master. And importantly, upon execution of the search warrant, a constable shall forthwith complete a report describing anything seized, whether specific in the search warrant or not, and shall forthwith serve a copy on the owner or occupier. Within 14 days, deliver the copy to the master, file a report in the High Court, and then we go further on to say that the Commissioner of Police can organize the safekeeping of that evidence either in his own custody or someone authorized by him to receive it. What does that mean? We can lawfully provide for the FBI or certain computer-related agencies that can scrub, or any agency authorized by the Commissioner of Police to have custody of evidence in the chain of command procedure so that we can data scrub, capture, and manipulate information. The prosecution and investigators at the TTPS have the ability to do that so that we can better track criminal activity. The provisions of providing notice and filing in the court obviously are an aid to proportionality and to making sure there's a right to fair hearing and due process balancing in the equation that was absent in the 2011 bill. We have also allowed, notwithstanding any other provisions, that a police photographer may take photographs of things served in the presence of a justice of the peace. We formalized the forms for the usage of that. We provided for the mechanisms for the restoration of property in certain circumstances. We've catered for all of the scenarios. What happens if the person who owns the thing that is seized refuses to sign? Then we provide for the certification of evidence where there's an involuntary act on the part of the accused or person who's suspected. We've gone through the methodology of making sure that each step of the process has been identified in the parent law in the manner that we set out as the amendments to Section 5 via Clause 4 demonstrate. We have gone next to Clause 5 in Section 6 of the Act. We seek to clarify the issues of warranting, whether search warranting or arrest warranting. We've been very specific in stating the type of warrant that we're looking for. In this case here, it's the arrest warrant that we're looking for. The amendments there, of course, are just to clarify the law and make sure that there's clarity in process. Clause 6 of the bill amends Section 7 of the Act in treating with the summons aspects. We have again formulated the matter of what the summons should look like in a scheduled form, as Form 5 in Schedule 1 demonstrates. But we've said very importantly in the amendment that Clause 7 proposes to Section 8, we're saying in determining whether to issue an arrest warrant, a master shall consider the nature and seriousness of the offense, the likelihood of the accused evading service of a summons, the character, antecedents, associations, and social ties of the accused, and any other factor which appears to be relevant. We've thought it prudent to put forward the conditionalities so that the court is guided on the standards and weight of its decisions and how it gets to a decision in the manner that we think is most prudent from a proportional perspective. We've gone further to, of course, provide for the master managing in circumstances where you're brought before a magistrate. So let me stick a pin for a moment. In this formula of removal of preliminary inquiries, the process flow looks as follows. You come before the court by a summons, by an arrest, by a complaint or an indictment. The law contemplates that you really come before a master of the High Court, a criminal master. That criminal master is somebody who will conduct an initial hearing within the parameters of Section 11 of the Act, who will do a sufficiency hearing thereafter, who will then consider whether you have a case to answer or not, who will send the matter by way of a scheduling order to the High Court, giving the information to the DPP, to the accused, etc., who may decide that you don't have sufficient evidence and may dismiss it, who will inform the DPP, who has a second bite at the cherry. He may send it, the master, to the magistrate. The magistrate will hear summary matters, or in certain circumstances, deal with issues of bail, etc. So what we have sought to do is to use the existing system of law. Criminal masters, which we have, and more of whom are coming on board, magistrates who are in operation, so that they now start dealing with the summary matters and get on with justice. Magistrates who are now, without the encumbrance of 102,000 traffic offenses, which they don't need to hear, they rather spend their time on the 43-odd thousand cases left for them, remove that 102,000 cases per annum from their docket, in an environment where we have added computerization, case management, judicial research officers, judicial officers as assistants into the scenario. All of those matters having been approved by the cabinet right now, and out for hire they are. In other words then, all of this is going on right now. In the same way that we were able to operationalize the criminal division of the Children's Court in 2 brand new courts which are up and running, it's the same way that we effectively intend to operationalize this law. If I go to Clause 8 and I look to the insertion of a new Section 8A, here's where we're disaggregating now indictable, triable either way, and offenses which are associated with either pack. Here in Clause 8, capital A, as we deal with that insertion, we're dealing with the indictable only route. In subclause 2, we treat with the either way category. In subclause 3, we're dealing with summary offenses which ought to follow the indictable offenses. And then in subclause 4, with the either way offenses and summary offenses. Effectively, put quite simply, indictable goes to the High Court. Summary, Magistrates Court. If you have mixed charges, indictable, something that is either way, or something that is summary, all go upstairs to the High Court. If they are purely summary matters, they stay downstairs. If something has gone indictably, the DPP, in his fulmination, may consider that that ought not to be indictable, remove it from the High Court, send it to the summary court. So we've managed the point of first contact, magistrate or master, DPP or registrar. All of these are now set out in prescriptive fashion in the bill before us and in the amended act, as we hope the Senate will consider appropriate to pass. We go next to the routing in Clause 9. Clause 9, of course, treats with the master treating with bail in the circumstances set out there. The master, the warranting, the endorsement on the bail, you can issue a warrant at the time and set bail in advance, and it's so endorsed onto the matter. Clause 10 amends Section 10 of the Act. We've harmonized the utilization of the expression clerk of the peace. Remember, as a Senate, as a Parliament, we removed untrained persons who were not attorneys at law from occupying the position of clerks of the peace, and we've instead put a magistracy registrar and clerk of the peace, who is a judicially held, position as a qualified attorney at law. The intended date for proclamation of that is supposed to be the 1st of February. We have received communication from the judiciary asking us to adjust that timetable, and we have agreed to present that to Cabinet. It'll be adjusted to the 31st of March because the advertisements are out and they need a little bit more time to complete the interview process to fill those positions. I might add that the existing clerks of the peace are not going to be put out on their heirs. They continue into function, having provided yeoman service to Trinidad and Tobago in a slightly different capacity with no derogation of terms and conditions in their respective dockets. Clause 11, we cause amendments to the initial hearing, which is an important anchor point of the legislation. And here is where we tidy up the trial on indictment and summary offences routes. We contemplate that we have particulars for the scheduling of the orders as we make an amendment to subclause H, and we say specifically what it is the police shall submit to the Director of Public Prosecutions, prescriptively in the new Roman II Common A. We then, in clause 12, cause an amendment to section 12 of the Act. We're massaging here the either way and summary routes in the manner that we suggest in that. Clause 13, we've moved the time frame from 5 to 10 days for the notice of alibi, and we've added in a procedural safeguard in the new section 3A, subclause 3A, as to how the Director of Public Prosecution shall consider the alibi prescriptions that we add into there. Clause 14 amends section 15 of the Act. We allow, very importantly, a new subsection 3. In that new subsection 3, we're allowing for the master to effectively manage the irregularities in process, as opposed to rely upon the criminal proceedings rules themselves or just the inherent jurisdiction of the court. We're allowing for it to be expressed in a new section, subsection 3 of section 15. We go next to clause 15, which treats with section 18 of the Act. We've again removed Commissioner of Prisons, used the expression the keeper, because that is consistent with 3 other pieces of law, as we've now come to manage that titling of the position of keeper as against Commissioner of Prisons. Clause 16 causes an amendment to section 19 of the Act. This is part 3 under the rubric sufficiency hearings. And we have specifically managed to treat with the delay factors, that no delay in the new subclause 5A should affect the scheduling order in the circumstances that we provided there. Clause 17 amends section 20 of the Act. Here it is we're adding a better proportional route. We're making sure that it's not only the prosecution that has that one-sided approach in the sufficiency hearing to allow for the treatment of oral submissions. We've actually balanced now both the prosecutor and the defense because it was not appropriately addressed or proportional in that regard. Clause 18 treats with the conditions which are set forward for a witness statement to be filed by the prosecutor. And we put in the safeguards in respect of children, those whom are under 14 years and those who are above 18 years. And we've made it consistent with the Children's Act, in particular, Section 54 of the Children's Act. We've added for the safeguards for the interpreter, the person who is incapable of hearing, the safeguards for certification by the witnesses to those events in the manner that we set out there. Clause 19 treats with the master on application of the prosecutor or the accused permitting either of them to file further evidence. Again, we thought that this was a better procedural safeguard to allow for the balance between prosecutor and defense. Both should have the equal access to the position. Clause 20 is where we treat with the review of evidence submitted by the prosecutor. And here you will note that we're treating with discharge or being put on trial or making any other order. But it's tied to sections 24 and 25. And in section 24, when we come up to clause 21, very importantly, we're removing the reference to a prima facie case. No longer will the master be satisfied that there is a prima facie case against the accused. And of course, we've deleted the definition of prima facie because it was something flowing from the common law position in the R versus Galbraith decision in particular, the 1981 case, which the lawyers will be well familiar with. We've reverted to sufficiency of evidence as Section 23 of the existing law provides and as the 2014 law contemplated in the committal proceedings route. In Section 25, by Clause 22, we again harmonize the removal of the prima facie element back to sufficiency of evidence, which is the current law. In Clause 26, we're seeing amendments, in Clause 23, we're seeing amendments to the Act by the insertion of a new Section 26A, where we're treating with what happens where you've lost documents, originals can't be found.
Attorney General, you have 5 minutes.
Thank you, Madam President, where we can have the return to the registrar's information and certification of information. That sees the addition of a new 26A, 26B, 26C in the circumstances set out. 26B, we treat with the fresh evidence approach. 26C, where the DPP may go summarily and the process which the DPP ought to exercise in getting there. Section 27 is amended by Clause 24, and this is the delay provision. In this particular provision, we're saying that once the DPP has reached the stage where he's received the order to put on trial after the scheduling order, the DPP has 12 months, this is the existing law as it's set out, to proceed, unless he applies to extend the time, of course, which he's permitted. And if after 12 months that does not happen, then, of course, the matter is put out of the court. But what we've done, very importantly, in subclause 3, we've amended the circumstances where you would not have a sufficiency hearing. The language is put in the inverse sense. It was set that way in 2011. Where the DPP prefers and files an indictment, a sufficiency hearing shall only be conducted in the following instances on the request of the DPP. In other words, then, if the DPP does not request the sufficiency hearing, it goes automatically to indictment. Importantly, I'd like you to observe that we're adding in what is the existing law in Section 23 of the Chapter 1201, where the accused is charged with an offense involving serious or complex fraud. Importantly, where a magistrate was unable to complete a preliminary inquiry before the coming into force of this act, or a master is unable to complete physical or mental infirmity, resignation, retirement, death, inability for any other compelling reason. This flows out of the interpretation summons which I took to the court in the circumstances of the Marcia A. Caesar matter, where the Honorable Madam Justice Gobin held that it was entirely proper and sensible for the Attorney General to have done that. And her observation in that case was quite important. You can't send the matter before another judge, another magistrate. It would have to go de novo. It would have to start again, all anew. But importantly, this allows the DPP to skip past that process. Serious fraud, other disability, wasted time has happened. Let's go directly and have you answer the charge in a fair environment with due process applied. Madam President, we have very important amendments by Clause 25, which treat with the circumstances of professing guilt. That is to be found in Clause 26 as well. I recommend that honourable senators consume what these clauses are doing. We're allowing for a simplification of the process where somebody, because of perhaps good plea bargaining legislation, better prosecutorial environment, we now manage the process of an admission of guilt and how that is to be taken forward to ending the process. Madam President, that is to be found Clause 27, 28, etc. 28, we're dealing with how the accused gives notice. We're putting in better safeguards, and then we amend the schedules. 45 minutes is nowhere near enough time to do justice to the kind of law that we're bringing here. I urge honourable senators to put forward their suggestions during the course of debate. I do give the undertaking that I will be giving a very fulsome reply on the operationalization and other issues that honourable senators may raise. Suffice it to say, this law is proportionate in the government's view. It is a material improvement on the 2011 law, and it is something which I recommend, and in those circumstances, I beg to move.
Honourable Senators, I shall now propose the question for debate. The question is that a bill entitled an act to amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, be now read a second time. Senator Ramdeen.
Good afternoon, Madam President. And I stand here to contribute to an act to amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011. Madam President, the Attorney General, in piloting this bill, has given us in the Senate an entire overview of the history of preliminary inquiries and where we've come some 400 plus years ago to where we are today. And I don't think that there is anyone in Trinidad and Tobago today that would argue with the proposition that the time has come, we're 8 years on, that we should put an end to this issue of preliminary inquiries. The Attorney General has also given us a complete overview of the position that the government has taken with respect to their fight against crime and criminality. What the Attorney General, to quote him, says, the most important issue that faces our country today, and no one can argue with that. But the Attorney General was very correct, Madam President. Where we may perhaps part ways in relation to this debate is the operationalization of this piece of legislation. The Attorney General has given us what we've come to be a very familiar shopping list of all of the legislation that the government has passed, what we are supposed to expect as a society from that legislation. But what I want to delve into, Madam President, is really where we are at now. Because as a society, we've heard about the courts that have been opened, we've heard about the legislation that have been passed. We've now been faced with this piece of legislation, which, from where I sit, Madam President, is clearly a work in progress. And I want to start this debate this afternoon on behalf of the opposition by first of all indicating that I want to thank in the opposition, since this piece of legislation was laid in the other place on the 9th of November 2018, the opposition has met on a number of occasions, led by the leader of the opposition, with a number of interest groups and a number of persons who are affected by the operationalization of this legislation. And what I will do, Madam President, is in my contribution, I want to highlight certain aspects of the bill that will affect certain categories of persons, and I know that the Attorney General will take on board what we are saying. Just for completeness, Madam President, the opposition and a group that has been nominated by the leader of the opposition has met, and let me list it out for you: attorneys at law, members of the Law Association, justices of the peace, persons who are before the court now who are to be affected by this legislation, magistrates, and members of the public. And since the 9th of November, we've collated that information that will form the basis of the contribution that the opposition will give here today in relation to how we treat with this particular piece of legislation. And why we've done that, Madam President, is because this legislation since 2011 was piloted 2011, 2015, with 2018, 2019 to bring substantial change to the criminal justice system. If it works, Trinidad and Tobago will clearly benefit. If it doesn't, the consequences can be disastrous. And that is why we must be careful about how we deal with these changes. Nobody here can give the Attorney General the undertaking that nobody here doesn't want this legislation to work. We all want it to work. Because once it works, it doesn't matter who brings it. This is the work product of two different administrations. And we've come here today to try and put forward what we consider to be the right, what we consider to be the direction that we should be moving in. But, Madam President, the Attorney General did indicate statistically, we don't have the benefit of all the statistics. Some of them I've taken down. But statistically, the Attorney General has given us an overview of what the backlog is in the criminal justice system as we speak presently. Let me take those statistics, Madam President, and present a picture to the country so that people can understand, those that are here can understand where we are in relation to this thing called the criminal justice system. The Attorney General rightfully made reference to a matter that the Attorney General brought to the High Court. In the Attorney General of Trinidad and Tobago, in the interpretation summons, versus Her Worship Maria Busby Cadell, Earl Cadell, Chief Magistrate, Director of Public Prosecution, and involved in that was the Law Association, the Criminal Bar Association, Ramchand Lakshmidiyal, Brian Seepersad, Desron Nero, and 2 other persons. Madam President, I want to set the background of this conversation that we are having by reading into the record of the Hansard the position that the applicant in this particular case, Achille Charles, found himself in as a result of what we are trying to treat with here today, which is this system of preliminary inquiries. And this is what the judge had to say, Madam President, and I quote, "In the case of Mr. Charles, the dire consequences of his matter being rendered abortive have been disclosed in his affidavit." Listen to what this citizen of Trinidad and Tobago, who is presumed innocent for what it's worth under the Constitution, had to go through. He was charged for murder on the 5th of December 2010. He has been in custody since that date at the Royal Jail in Port of Spain. The conditions there, that is in the jail, were found by this court almost 1 decade ago to be inhumane. Listen to this part, Madam President. There is no reason to believe that there has been any improvement in those conditions. For a decade, the High Court declared those conditions at the Port of Spain prison to be unconstitutional, cruel, and inhumane, and they remain so as we speak in 2019. The hearing of his preliminary inquiry finally began in January 2012 and spanned 5 years until April 3rd, 2017, about 2 weeks before the elevation of the Chief Magistrate. There was no indication on that date that she would not be available thereafter. More than 60 witness statements have been received, and several witnesses have been cross-examined on their statements. Mr. Charles paid $150,000 for legal representation over the period which he cannot recover. He will have to pay for representation for a new hearing. He has no means of raising further funds for his defense. That he should have to start over this process is oppressive. Now, Madam President, I want to just put this in the context of the bill that we are being asked to debate today. And the Attorney General made specific reference to Section 27, which I will come back to. But that is the section that the Attorney General made reference to that is designed to perhaps cure this situation that occurred that Mr. Charles found himself in. But, Madam President, with all that has been said by the Attorney General, this is what a High Court judge had to say about the administration of justice in Trinidad and Tobago today. And I quote, "What has happened here is a travesty of justice. The stain on the administration of justice will remain indelibly long after the cries and protests of justifiably angry, suffering prisoners have gone quiet, and long after the families of victims who too have been waiting for justice to be done resign themselves to further delay. It may go some small way to alleviating the pain and the injustice of this on all sides if those responsible are held to account." And I want to come back to that. Almost 2 years on since the Chief Magistrate's elevation, the initial shock and disbelief that this could have happened has dulled. But the ill effect, listen to this, Madam President, but the ill effect on the public confidence in the administration of justice and the institutions which allowed this to happen, whether through lack of due diligence, as suggested by the Law Association, or recklessness, will persist. So far, the financial cost to the taxpayer is limited to the cost of litigation in this and other cases, which have been filed as a result of this colossal misstep. You see, Madam President, as legislators, we look at the bill, we look at the provisions, we can tell whether they are proportionate, whether they pass constitutional threshold. But what we must understand is that there's a real life effect of this legislation. This is legislation that affects the lives of thousands of people and has the potential to cause a continuing effect on the lives of thousands of people. And what I want to ask myself today in this debate, Madam President, is this. After the courts have been built, the rules have been passed, the legislation has been amended to increase judicial capacity, we're told, up to 77% by the Attorney General, from 35 judges from 35 to 64. After the Children's Court has been opened, what is the state that we find ourselves in terms of being ready to operationalize this piece of legislation? The most important body, the most important institution that is responsible for the operationalization of this piece of legislation by the 30 clauses that we are asked to amend today of the 27 law is the Office of the Director of Public Prosecution. Coincidentally, over the past week, we've had statements by the Director of Public Prosecution before a Joint Select Committee of Parliament, and we've heard what that position is. But, Madam President, there's a reality behind this legislation. This legislation is legislation, when proclaimed, gives a limitation period to the Director of Public Prosecution to file an indictment in certain cases, save and except Schedule 6. How is the Director of Public Prosecution, or let me put it in a question, rhetorically, is the Office of the Director of Public Prosecution ready to implement this piece of legislation that we are asked by these 30 clauses today to amend, the 2011 law? Well, Madam President, let me put in context now. After we've heard about the judicial system and judicial capacity and all of these things, let me tell you what the position is at the Director of Public Prosecution's office. And if we don't get this right, if we continue with the DPP's office in the position that it is in today, I want to say, and I make no apologies for saying this, we are going to cause more harm than good to the public interest in Trinidad and Tobago. Madam President, let me read into the record what the position is at the Office of the Director of Public Prosecution. At present, there are different categories, as we all know, in relation to the staffing. There's the Deputy Director of Public Prosecutions, Assistant Director, Senior State Counsel, State Counsel 3, State Counsel 2, and State Counsel 1. These are the people who are directly mandated by these amendments to carry out and, as to use the words of the Attorney General, to operationalize this legislation that we are being asked to amend today. Are we ready? Let's judge for ourselves. Let Trinidad and Tobago judge. The total positions of deputy DPP are 3. How much are they filled? 1. Assistant Director of Public Prosecution, 6. How many are filled? 2. 4 are vacant. Senior State Counsel, number of positions? 15. 15 Senior State Counsels. How many are filled? 2. 13 vacant. State Counsel 3. How many positions on the establishment? 25. How many are filled? 13. How many are vacant? 12. But listen to this one, Madam President. State Counsel 2. Positions 46. Positions filled 8. Number vacant 38. State Counsel 1, 33. Positions filled 28. Number vacant 5. So at the end of the day, the equation is this. On the establishment of the Office of the DPP, that has to operationalize this, has to take the evidence at the sufficiency hearing and determine whether an indictment should be filed. This is the office that has the responsibility to do that. There are 128 positions on the establishment. 54 are filled and 74 are vacant. Madam President, if we pass this legislation, which everybody who wants to solve crime, who wants a better Trinidad and Tobago, who wants safety and security for their children and their family, and for the society that we live in, village, town, wherever. If we pass this legislation, what is going to be the position where we set a limitation period for the Office of the Director of Public Prosecution under Section 27 to be able to file an indictment in a year in non-Schedule 6 offenses? And the DPP is in a position, this is the position that the office finds itself in. Madam President, we have to ensure that the main wheel that has to turn the wheel of justice in relation to what we are doing here is resourced. It makes no sense opening the children's court, putting systems in place at the prison. All of these things that the Attorney General has talked about, 100,000 cases out of the magistrate court, 43,000 in the High Court. How is this going to effectively bring justice to the victims, ensure the rights of the accused are secured, when at the end of the day, the prosecutors, we have a new definition for prosecutors, the prosecuting authority of Trinidad and Tobago that vests in the office of the Director of Public Prosecution is starved of resources. How could that be right? What is going to be the result of the passage of this legislation in relation to that? So, that is the position there. Now, Attorney General, through you, Madam President, to the Attorney General, it doesn't fall within your ministry, and I understand that. But the Attorney General has come to the Parliament and has told us the Office of the Director of Public Prosecution in San Fernando, they found accommodation for them there. The Office for the Director of Public Prosecution in Tobago, they found accommodation for him there. And now for the Office of the Director of Public Prosecution in Port of Spain, they have found accommodation for them there. Madam President, with respect to the Office of the Director of Public Prosecution in San Fernando, since October 24th, 2017, since October 24th, 2017, that's almost 18 months. You know what the position has been, Madam President? A place has been found. It has been in this place called the Property and Real Estate Services Division and the Commissioner of Valuations since that date to now. So the office of the DPP in San Fernando can't get accommodation because this is tied up somewhere in this place called the Property and Real Estate Services Division for more than 18 months. And we want the DPP to do all that he has to do under this piece of legislation. Is he going to do it without a proper office? Is he going to do it without proper staff? Don't you think that the government and the cabinet should devote the resources to the Office of the Director of Public Prosecution to ensure that that body, which is constitutionally mandated to carry out what is given to them to do under this piece of legislation, is properly resourced? That should be our number one priority. Madam President, I just want to end this part of it by saying the government has tried, administration after administration. We understand what the problems are at the Service Commission. Things take long. So administration after administration, they've gone and gotten contract workers to be able to carry out the position. Well, Madam President, you know what the position on contract workers is? There are 30 positions for contract workers at the Office of the Director of Public Prosecution. Out of the 30, 9 have been filled. So, Madam President, it doesn't paint a very good picture for the people of Trinidad and Tobago. And I want to leave that aspect of it there for a little while, because it is very disturbing that the government's position is that crime is the number one priority for the government. Resources are being devoted. Resources are being devoted. And let me just get to that aspect of it, Madam President. In the budget documents that we were provided with respect to this financial year, Madam President, you know what the resources that have been devoted to the judiciary are for this year? $416 million. $416 million. And this is the institution that is really the driving force of this piece of legislation. So we've had, the Attorney General has told us they've appointed 5 masters. That has been done in the last 2 weeks. No problem, Madam President. I want to put my position on record, because the last time, a year and a half ago, that I put my position on record with respect to people being appointed to particular places, so it really fell apart after that. So I want to place my concern, Madam President, on this. This is an important piece of legislation. The masters, the criminal masters that are to be appointed to operationalize this piece of legislation, they perform perhaps the most critical function to get it right. And I want to be assured through you to the Attorney General that the persons who are being appointed to fill these positions are qualified to operationalize this piece of legislation. And I want to say at the outset, Madam President, I'm not going to call any names, not going to make cast any aspersions on anybody. I know who the 5 persons who are appointed to be masters within the last 14 days, what the position is. And I can say, with the little experience that I have, that I am not satisfied that the persons who are appointed are able, from my little knowledge, my little experience, to be able to carry out these functions. That's all I want to leave it there. Because, Madam President,
Ramdeen, I just want to caution you about the relevant standing order. And you know the standing order, so I'm cautioning you. I would advise you to leave it there.
so that is the position with respect to that. But, Madam President, the position is this. Throughout these meetings that we've had, with respect to finding out, well, what is the position with the administration of justice in relation to all that the Attorney General has told us about building out the courts, the children's courts, putting in place all of these things that are supposed to operationalize this piece of legislation. So, position is this. There is a particular provision under this legislation, a very important provision that deals with these new provisions that the Attorney General is asking us to amend the principal legislation to deal with statements by, let me get the actual section. It's the amendments to section 21(4)A and the amendments to section 21(3)A and 21(4)D and D and small a. These are all the provisions, Madam President, that deals with the taking of the statements. And there is a specific provision that very commendably the Attorney General has put in with respect to persons who have to get their statements, these are the witness statements, translated, and how that process is to take place, and who is to do it, and how it is to be certified. So we want this to work. Section 21, as amended, says that where a statement is made by a person who does not speak English, this is the amendment, Madam President, that we're asked to put in. His statement shall be taken through an interpreter and shall be Roman numeral 1, recorded on his behalf, read aloud, and translated to him in English before he signs it or makes his mark thereon, and 2, Roman numeral 2, accompanied by a declaration that states that it has been read out aloud and translated to him, and he has signed or made his mark thereon. Very, very good provision, a very good improvement on the law. Will it work? Well, let's find out. Tuesday, December 11th, 2018, Newsday article, written by Laurel Williams. Headline, translators want their money. Translators and interpreters are owed more than $200,000 by state agencies for services done, and they want their payments. With days to go before Christmas, the workers said they do not have any money to celebrate the holiday or buy presents for their relatives, saying they dutifully spent long hours assisting police and the judiciary with investigations. They complained that they were broke. When we asked for our money, they keep saying funds were not released. We are spinning top in mud here. We are working, but we are not getting paid, yet we continue to work. Sometimes in one day, we work a 12-hour shift. We have to go to different courts, and we have to pay our money to get to different locations. It is hurting to know we already worked and cannot get paid. All we are asking for is our money. Well, Madam President, and I don't go into what the judiciary says is the response and all that, but Madam President, if we are passing legislation for which there's a critical role to be played by interpreters, And that is at the heart of one of the amendments that we are being asked to provide for here in the 2011 legislation. And nobody can stand here and say it is not a provision that is in the best interest of the criminal justice system. How can we find ourselves in a position where the public body that is responsible for paying these people last year spent $404 million and can't get $200,000 to pay these people, the interpreters? Do we expect it will work if that happens, Madam President? Well, the answer is no. So let me go to another aspect of it. And Madam President, this is not us saying this to criticize, This is for us saying this so that it will get it right, so that when the legislation is passed, we won't find ourselves in this position. Can you imagine what would be the position, Madam President, where in some serious offense, there is a witness who can't speak English, and when they go to give their witness statement to the police, the translators say, we're not prepared to do it because we've not been paid. What is going to happen to the administration of justice there, to the accused and to the victim? So what I indicated at the outset, Madam President, that one of the groups that we spoke to are the justices of the peace. Well, they have an extremely important role to play under this legislation as well, because 6 of the amendments that we are asked to pass today deal with the justices of the peace are the persons who have to certify these statements that are being given by the police officers under this new regime where witness statements are the order of the day. Madam President, I don't know how many of us know, and I want to say this through you to the Attorney General. Madam President, do you know, I ask rhetorically, what the stipend of a Justice of the Peace is in 2019 today? The same people, last night I spoke to one from Sawa, and he told me for the day already, he had 5 police officers came to him to authenticate statements. These are people who are paid a stipend. They are crucial to the operationalization of this piece of legislation with these amendments. They are the persons who are charged with the responsibility of ensuring there is fairness to the accused when the police officer brings someone there to give a statement under this piece of legislation. Madam President, the stipend for a Justice of the Peace in 2019 is $1,000 a month. $1,000 a month. This is a person who is on call 24 hours for the day, They go by their house at 10 and 11 o'clock in the night when they pick up an accused, or an accused decide he's ready to give a statement at some wee hour of the morning, knocking on their door. And the justices of the peace, who are critical, just like the prosecutors in this piece of legislation, their stipend is $1,000 a month. I mean, are we really serious? Is it because they have an association, Justice of a Peace Association? Is it that nobody communicates with these people to understand what their plight is? Today, Madam President, through you, I want to ask the Attorney General. Attorney General, it falls under your ministry. Please look into the plight of the Justices of the Peace. They perform a critical role and a critical function under this piece of legislation. And simply for being on call 24 hours of the day, Madam President, do you know that when we did our consultations in this matter, that 2 justices of the peace in this country have been murdered? 2 justices of the peace have been murdered, and there is all the evidence points to the fact that it had to do with them giving evidence in matters before the court. They put their lives on the line every day, Madam President, when they give a statement. You know why? Because it is because of their statement, it is because of their authentication that justice could be done and fairness is presumed in statements that they are given. That is the role that they play. And what happens is that they become targets, because if you get rid of them, you virtually get rid of the statements. And that has happened over and over. And therefore, Attorney General, in addition to the stipend, let us pay a little bit of respect to the justices of the peace and at least provide them with a little security when the day comes. They only don't risk their own lives, They risk the lives of their families as well. So, I want to put that on the record. Now, Madam President, the Attorney General made a very, very important intervention with respect to these amendments, and I want to get to that, which is the provisions the Attorney General talks about that deals with the storage and the manner in which evidence, in whatever form as defined by this Act, is to be dealt with. The section that is to be amended under the current law, Madam President, is Section 5. And there's a procedural code here that sets out what the position is. Now, for all intents and purposes, what the Attorney General has proposed is what the common law is at present. There's nothing wrong with that. That is not a criticism. It's good that we've put it into statute. There are some other additions that the Attorney General has added in. It's very commendable. But this is what I want to get at, Madam President. If the law is presently, by virtue of the common law, what has been put into statute here today in the amendments that we are being asked to propose, to approve, well, why is it that the police officers who have to operationalize this legislation under Section 5, the Attorney General, I don't want to repeat it, has gone through all of the different, there are 8 new subsections that the Attorney General has introduced. Well, Madam President, let me just put on record what the position is with this. You see this? This that the Attorney General has introduced here today, at present, no, I can say so. Let me put it this way. The police service, more often than not, does not do what this legislation is asking them to do now, even though it is the law. And let me tell you what the liability of the state is in relation to that. And the Attorney General will know very clear. I want to go back to a question that I asked to the Minister of Energy and Energy Industries. Madam President, I have a document here from the Engineering Battalion, Defense Force Headquarters, dated the 5th of December, 2018. And you know what this relates to, Madam President? This is a document that sets out all of the equipment that the Defense Force has that they have seized in relation to criminal matters.
Madam President, I apologize. My learned friend well knows that what he's referring to, Standing Order 46. He must be a little bit, 46-1. Madam President, my learned friend is referring to a matter that is sub judice, I do believe.
Senator Ramdeen, is that correct?
No, lady, I am referring to, this is not a court document.
Is what you are reading, is it related to a court
No,
matter?
it is not. Okay. This is a list of all of the material that is in the custody of the Defense Force pursuant to what they are being asked to do here under this amendment to Section 5. Now, Madam President, the position is this. If the police are not doing it now, when this is the law, what is going to make it different that they're going to do it now when you put it into statute? What is going to make difference? When you put these obligations on the police to provide a report, take pictures, present the material to the Commissioner of Police, the first thing one has to ask, well, where is the Commissioner of Police going to store all of this? Where is the Commissioner of Police going to store all this material? And what is going to be the consequence? The one thing that I found missing, Madam President, is what is going to be the consequence of an officer breaching any one of these provisions? Because you have all the duties that they have, but there's no sanction when none of this is done. And what is not sub judice is this. What is not sub judice is that there are decisions of the courts that have shown, decided, not appealed, that have decided this is costing the taxpayers of this country hundreds of millions of dollars, you know. Hundreds of millions of dollars. So I hope that something is done in relation to operationalizing this piece of legislation that would somehow make the police obey the law and do what they have to do under the piece of legislation. So that is that. Madam President.
5 more minutes.
Thank you, Madam President. Madam President, 2 sittings ago, a written question was answered in this Parliament. I think it was the Attorney General who had answered the question. The Attorney General can tell me if I'm wrong. But I had asked, what is the time that it takes the Director of Public Prosecution to file an indictment in a capital matter at present from the time the documents are delivered to his office? And the Attorney General answered that question, and he's not the answer was 6 years. 6 years. It takes the Director of Public Prosecution 6 years to file an indictment in a capital matter for a man who is presumed innocent under the Constitution. And we are passing legislation today, and I say so respectfully, Madam President. How is that time going to be cut down when we pass this legislation? This is dealing with one aspect of the backlog, which is the position from charge to committal. What is going to happen from the position of committal to filing the indictment? When what we are doing today, and perhaps I want to say so, Attorney General, Madam President, through you to the Attorney General, is this. When you are familiar with the criminal justice system, it is so ironic that in capital matters, the period is 6 years. In non-capital matters, it's not less, it's actually more. So you have cases the Attorney General referred to of incest, rape, sexual offenses. At present, the period to file an indictment for those is even longer than 6 years. And what I'm saying, Madam President, is that if we are going to fix the system, let us do it properly. Let us do it where we can see results. Let us not do it because we can come here and say we pass legislation and it may work. Let us ensure that when we pass legislation, it will work. And Madam President, as we speak, the system is broken. As we speak, the whole of justice, Madam President, where people look to, or what I should say people used to look to as a light, an institution where they can go and enforce their rights, right, is no longer that today. And the difficulty that we have, Madam President, is while we are spreading the resources across the floor, as the Attorney General has so graphically described about courts, judicial capacity, the truth about it is, Madam President, when you speak to the people who are directly involved in the criminal justice system, and let me just take out the word criminal justice system, when you speak to the people who are involved in the justice system, the truth is that those persons who devote their life to public service on behalf of the people of Trinidad and Tobago are not being provided with the resources to do their job, to discharge their duty in the public interest. And that is the saddest thing that is happening today, Madam President. And this piece of legislation, well-intentioned as it is, to bring about changes to the criminal justice system, to make improvements to that system, to provide for all of the things that can improve the system, is not going to yield the results to the common man in Trinidad and Tobago that we would like to see. And at the end of the day, Madam President, while we sit as legislators here, the position is this. We must ensure that what we do here drills down to the common man on the street. The prisoner inside Golden Grove, maximum security, and Royal Jail must reap the benefits for what we do here today. And if at the end of the day, the accused and the victim together do not benefit, we have failed as a legislator. And we must ensure that we do everything to ensure that we don't fail, Madam President. I thank you.
Senator Seepersad. Thank you, Madam President, for the opportunity to contribute to the debate on the bill entitled An Act to Amend the Administration of Justice, Indictable Proceedings, Act 2011. At the onset, I would like to state that I am not an expert in these matters. However, I am very familiar with the term, justice delayed is justice denied. Therefore, given the current enormous backlog of criminal cases, the fact that pre-trial detention could last up to 10 years, and some individuals are awaiting trials for periods which are longer than the sentences that can be imposed if they are convicted, it is obvious that for us to continue to maintain the status quo is foolhardy.
Consequently, in this scenario, doing nothing is not an option. The bill before us advocates the introduction of judge-alone trials. While this is one system which may accelerate the processes in the criminal justice system, it is not to be viewed as a panacea for resolving all the problems being faced. The introduction of a new process or the modification of an existing one requires intelligent analysis, planning, strategy, construction, deployment, and a feedback loop for measuring effectiveness and making adjustments. This is an ongoing and cyclical process to keep improving. Madam President, I expect that these steps are in train and this scenario of a failed system is not repeated in a few years. The new legislation allows the accused to choose between either trial by jury of his peers or judge-alone trial. It is also open to the accused to change their mind in how they want to be tried after a reasonable time. Therefore, persons are not prevented from having a trial by a jury of their peers. Madam President, there must be safeguards and additional procedures put in place to ensure that the rights of the individual are not violated and the high standard of justice is maintained. While judge-alone trials can potentially increase the efficiency of the criminal justice system, there are further measures that must be implemented, including robust case management system, proper witness protection program, appointment of additional judges and other judicial officers, use of modern scientific evidence such as DNA, setting up of a public defender's office, electronic monitoring. Additionally, the Director of Prosecution's office requires adequate accommodation so that it can be fully staffed. Currently, they're in cramped offices where only 73 persons can fit. However, the DPP requires a complement of 129 persons to function effectively and efficiently. It is therefore imperative that in acquiring adequate accommodation be addressed in the shortest possible time. Other issues that must be dealt with in the quest to reform the criminal justice system include improving the investigative capabilities of the police service. In concluding, Madam President, in addition to the measures and systems, some of which I've highlighted, it is imperative that adequate checks and controls are employed so that the efficiency of the justice system will be significantly improved. I envision set targets of, say, not more than 25 matters pending. No system will succeed without the adequacy of efficient and competent management and resources. Thank you.
Senator Simonette.
Madam President, I thank you for the opportunity to contribute to this debate on the Administration of Justice Indictable Proceedings Bill, which seeks to amend the Parent Act, which is an Act 20 of 2011. Madam President, this is an important debate and an important item of legislation concerning the criminal justice system and accordingly of deep concern and interest to all citizens. The debate is also important, Madam President, as it affords the country the opportunity to assess the performance of those on the other side, on which I will say more later with regard to the contribution of my learned friend, Mr. Senator Ramdeen. Madam President, the Magistrates' Court, the High Court, and our Court of Appeal are all courts of justice. They are not forums constituted to do book reviews or to deliberate on philosophical concepts. They are mandated to deliver justice. Madam President, for far too long in this country, in both the civil and more so in the criminal arena, our people have come to accept, and especially so in the criminal arena, that justice moves at two speeds: dead stop and slow. Accordingly, both victims as well as those wrongly accused and some lawyers rightly reject the continuation of the malaise. Justice can seldom be delivered by chronic delay, and especially delay that can be avoided if fine minds apply themselves to the task of reform. And I agree with Senator Seepersad, who adopts the old maxim that justice delayed is justice denied. The Attorney General has given a clear report on the statistics in the criminal justice system. And notwithstanding the attempt of my learned friend Senator Ramdeen to indicate that there is some greater calamity to befall us, drawn against those chronic statistics of paralysis of the system, there is no doubt, Madam President, that we are, on this side, are embarked on the right journey in the reforms that the Honorable Attorney General has been making. Madam President, the bill before us today comes after delivery, as the Attorney General has indicated, of a suite of legislative interventions that have sought to address the reform of the entire criminal justice system. Indeed, the reforms implemented by my learned friend, the Attorney General, were promised to be delivered by then Minister of Justice in the PP government, but as we now know, never delivered, never implemented. It is important to accept, notwithstanding the huffing and the puffing on the other side, that the parent legislation was introduced by the then PP government, so that the attempt to reform is nothing new. Unfortunately, it was derailed by the infamous Section 34 debacle. The reforms which the Honorable Attorney General has summarized as having been already implemented are no mere reforms. They are reforms that go to the root of addressing the delivery of justice and the delivery of justice with certainty. What this bill seeks to do in removing and abolishing the preliminary inquiry stage of proceedings is to ensure that that justice is speeded up and delivered in a timely manner. The Honorable Attorney General has already summarized some of the reforms that have already been put in place. The introduction of criminal procedure rules to address the issue of timeliness and procedural sobriety to criminal justice procedure, aimed at modernizing the Victorian criminal procedure that we knew before. The introduction of the Family and Children Court and Division and the Criminal and Traffic Division of the High Court, and masters to function in the criminal justice system. The introduction of masters is not new. So the complaint or the attempted complaint by Senator Ramdeen as to questioning qualifications is a little surprising given the history of the initiative to lift the qualifications and lift the functions of adjudicators in the criminal justice system, starting back with then PP Minister of Justice. But he comes today to raise red flags that simply do not exist. And I don't think that that impresses either those of us seated here or those listening on the various media. So, Madam President, when one looks at the genesis of the changes, one would start with Act 20, the Parent Act of 2011, which was introduced by the other side when they were in office. Undertakings were given, importantly, when that act was introduced. And those undertakings were given by the then Minister of Justice. Senator Ramdeen seems to be suffering some degree of amnesia in that regard. The undertakings were, one, the act would not be proclaimed unless and until criminal procedure rules were brought into place. The act would not be proclaimed unless the masters were recruited and appointed. However, as we know, what was proclaimed was Section 34, derailing the salutary attempt then to try to amend and intervene in a chronically flawed and inoperable criminal justice system. Of course, those undertakings given, never performed, have now been performed by this government and this Attorney General. Madam President, it behooves me to note that in the light of the true history, the opposition, as they are no longer PP, although they tried to re-erect the PP last weekend, but however, if you deny it, you deny it. It's out there in the public domain.
Please.
Madam President, I do apologize.
Madam President, standing order 46-1. Why is he celebrating our success over the weekend? I think it should be relevant to the bill.
Senator Simonette, please continue.
Madam President, my little friend, the Senator Obika, continues to mystify. An attempt to coalition that was lasted no longer than 24 hours is now published as being success. Well, good luck. Continue with that. The stance of the opposition is a clear and... Madam, may I have your protection, Madam President?
And any senator will... Senator Ramdeen... Senator Amin, please, could we listen? If you don't want to hear what the senator has to say, you have a choice. Senator Simonette, please continue.
Madam President, I thank you. The stance of the opposition now, both in another place and here, is the clearest example of their unfitness to perform the solemn duties of office. It is the clearest example of the inability of the opposition to put the public interest and the greater good of citizens ahead of their narrow political self-interest and the interests of their friends. Their conduct provides, Madam President, the clearest example of their inability to rise to the occasion in recognition of country before party. The work being performed by this Attorney General, not just on this bill, and Senator Ramdeen comes on each occasion with the same, if I say so respectfully, Madam President, diatribe. The law not properly drafted. It will affect somebody who didn't get paid. The law will not work because the people you're hiring not qualified. No meaningful intervention to criticize the actual provisions, the policy that drives it, or the content of the law. So that their conduct provides, again, the clearest example of their fundamental flaw and incapacity to perform and lacking in qualifications for the role of leadership of our beloved country. Madam President, the chronic delays in our criminal justice system has too often been tolerated pursuant to the old adage, it is better that 10 guilty persons should escape than one innocent person go free. And what the bill is attempting to do is to ensure not just that accused persons are incarcerated come what may, but to implement proportionality and balance in ensuring that those who are guilty are punished and those accused who are not guilty are released. And as well, and more importantly, the victims can come away with an appreciation and acceptance that justice has been delivered. Madam President, modern society must revisit that maxim, the 10-to-1 maxim. This government undoubtedly has demonstrated its ability and its competence to adjust the maxim so as to achieve that salutary balance between the interests of the innocent and the interests of the accused. And that is what the provisions here in this bill achieve in relation to the amendments being advocated for by the Honorable Attorney General. Madam President, the reforms have been delivered and continue to be delivered as this government is driven to deliver progress. The Attorney General is driven to deliver progress. And our Prime Minister and leader is driven to deliver progress. Madam President, as early as 1946, Lord Chief Justice Goddard, in a case Grundkowski and Malinkowski, 1946 Queen's Bench, page 372, recognized the galloping disproportionate treatment by judges in upholding the 10-to-1 maxim. That is, better to see 10 guilty men go free than one innocent man be accused or his guilt be imposed upon him. And this is what Lord Justice Goddard had to say. And I'm quoting from the case. The judge must consider the interests of justice as well as the interests of the prisoners. It is too often nowadays thought, or seems to be thought, that the interests of justice means only the interests of the prisoners. And what this bill seeks to achieve, Madam President, is the balancing of that interest, the reversal of a trend identified as far back as 1946. Again, Madam President, Professor Glanville Williams, a well-known criminologist and criminal lawyer, in his treatise, The Proof of Guilt, had this to say about the issue with which we now grapple. And I quote, "The evil of acquitting a guilty person goes much beyond the simple fact that one guilty person has gone unpunished. It frustrates the arduous and costly work of the police, who, if this tendency goes too far, may either become daunted or resort to improper methods of obtaining convictions. If unmerited acquittals become general, they tend to lead to a disregard of the law, and this in turn leads to a public demand for more severe punishment of those who are found guilty. Thus, the acquittal of the guilty leads to a ferocious penal law. An acquittal is, of course, particularly serious when it is of a dangerous criminal who is likely to find a new victim. For all these reasons, it is true to say with Viscount Simon that and he quotes, "A miscarriage of justice may arise from the acquittal of the guilty no less than from the conviction of the innocent." R.V. Sterland, 1944, Appeal Cases at page 324. So, Madam Justice, the living experience of our criminal justice system today, with its chronic delays, is twofold. The criminals in our society operate with a firm knowledge that the justice system is not working in a manner aimed at bringing crime under control. So that the disregard that Glanville Williams spoke of way back then in the 1940s is a living matter here with Trinidad and Tobago for quite some time. The second item that is relevant is that the chronic delays are continuing and to impose daunting and dismal effects on those who are charged with the duties of bringing criminal activity to account, and that is the police, the very clerks of the peace, magistrates, and judges in the criminal justice system. So that to continue with the Victorian preliminary inquiry as a procedural step in our criminal justice system, Madam President, is to continue a system which could adversely increase the cost of prosecution, lead to wasted expenditure and continued massive wasted expenditure in investigations, frustrate and demoralize hard-working policemen and women, continue deep-seated disregard for the law, which is something I have mentioned in regard when I made my contribution on the other bill the Attorney General brought earlier last year, late last year. And that disregard for the law could well lead to the unleashing in this country of desperate measures deployed by both citizens and others to bring crime under control. So that the amendments that we are seeking here are salutary. They they cannot be derailed by any of the submissions made or the items raised by my learned friend, Mr. Senator Ramdeen. The trust of the Attorney General's work is focused on reforming the criminal justice system, and not just in passing legislation, but in operationalizing the system. He has demonstrated that in regard to what the advances made with the Children's Court, with the Criminal Division, and with the anticipated Public Prosecutors Division that is to be implemented to afford qualitative prosecutorial assistance to those accused of crime. That cannot be derailed, Madam President, in my respectful view, by outstanding pay to translators or by the requirement of the DPP to recruit further lawyers to the department. It cannot be said that the government is putting the cart before the horse when in 2011 the parent legislation was introduced by the other side. But Madam President, may I say, the learned Attorney General is in good, eminent company with regard to his focused reformation of the criminal justice system. As early as 1965, Sir Hugh Wooding embarked and stipulated and advocated on the very changes that this government and this Attorney General have pursued and now implemented, continue to pursue, and continue to implement. Madam President, just 3 years after our country's independence, which is some 53 years ago, Hugh Wooding had the following to say at the 1965 Commonwealth Law Conference held in Sydney, Australia. And he said this: "The philosophy, therefore, should be that it is equally a miscarriage of justice for a guilty person to escape as it is for an innocent to suffer. Accordingly, just as the prescription of certainty as the standard by which guilt should be adjudged is intended to ensure within the limits of human error that the innocent shall not suffer, so appropriate procedures should be evolved in order to ensure so far as justly attainable."
Madam President, on a standing order 53(1)(b) of tedious repetition, I think the member has made this point several times. I'm very familiar with the standing order.
Senator Simonette, please try and tie up your points.
Madam President, how much time do I have left?
You have until 4:22.
Much obliged. So Hugh Wooding went on to indicate, and I quote, "The better then to attain the aims of justice, revised procedures which I recommend for consideration include," and he said this: "A, the abolition of the distinction long traditional but now largely meaningless between felonies and misdemeanors, and the reclassification of offenses by their greater or lesser gravity as either indictable or summary." And what we see the Attorney General doing in the bill, Madam President, is making the treatment of indictable and summary offenses and either way offenses dealt with in a certain way. giving to the master the power, for example, and the court, of having summary offenses wedded to indictable and heard in the High Court, which is very akin to the advice being given in 1965, 53 years ago, by Hugh Woodin. Hugh Woodin goes on to say, and this is very interesting, 1965, the substitution for a preliminary inquiry of a requirement that there be served on an accused when it has been resolved that the charge will be proceeded with indictably and not less than a prescribed time before his trial, a complete record of the evidence which it is intended to prefer against him. This should expedite a final determination, which is desirable since the most effective deterrent to crime is certainty and swiftness of punishment. And that is why I say the Attorney General is in good, eminent company. The removal of the preliminary inquiry, therefore, is to be accepted. It is to be congratulated. And the question is, how much longer shall we wait? How much more delay? What further is required to be done? Respectfully, Madam President, I've heard nothing from Senator Ramdeen. Indeed, he seems to accept that that is what we should be doing, notwithstanding his red flag initiative. The Honorable Hugh Woodin went on to say this, and to some extent it rings true now: liberty to the prosecution and to the judge to make any comment on any conduct of the prisoner, including his silence at any time that he may reasonably have been expected to speak or make a statement or give evidence, provided only that in the whole of the circumstances the comment be fair. Madam President, just to deal with one or two of the matters raised by Honorable Senator Ramdeen. Senator Ramdeen gave us a very impressive list of those that he and his colleagues had consulted, but respectfully, he did not condescend to particulars of what that consultation produced. Senator Ramdeen advises that the physical accommodation of the DPP ought, I'm not sure if the point he was making was that, but he said it, ought to cause us to proceed with some degree of caution and possibly delay, possibly putting off what we have come here to do or what ought to be done. As we know, and it is in the public domain, the DPP's office is soon to move to accommodations, I believe, on Park Street. No doubt to provide for the recruitment that he's already engaged in. Senator Ramdeen questions the qualifications of masters, but he doesn't question that there ought to be masters. And I'm not sure that that is a relevant criticism of the bill itself. Importantly, he tried to dismantle the proposed amendment to Section 5 of the bill, and I believe, to give him credit, it may have been because his time ran out, he failed to address the provision of Section 5 that indicates that the goods that are seized after they have been photographed, it provides, ought to be returned to the owners, and that is Section 5, Section 5, subclause 7C. If I read, the thing seized be restored to its owner after the photographs and forms have been filed. So that what the provision and the amendment is seeking to achieve, Madam President, is a system whereby evidence can be preserved in photographic form and property belonging to citizens returned to them in a timely manner. No doubt, because of this government's appointment of a police commissioner, who, as all can see, has been actively energizing the Trinidad and Tobago Police Service, the criticism that the police not doing it and didn't do it last year and didn't do it the year before ought to be rejected root and branch, and of course is irrelevant to the amendment itself. So that, Madam President, the last comment to be made on my learned friend's contribution, which is, and it's his repetitive refrain, that they are committed to supporting fixing the system, but they want to see it done properly. Sorry, Madam President.
I do not like hearing myself being referred to as I just did. It's a little disrespectful. Please, continue, Senator Simonette.
Madam, I do apologize, Madam President. Madam President, my learned friend, Senator Ramdeen's constant refrain is that we want to assist in fixing the system. We want to support good legislation, but we want you to get it right. But he has not made in his contribution any contribution to what he proposes as being the amendments that he considers salutary or that he considers would work to get it right. So that at the end of the day, huff and puff, we can't blow the house down. Empty barrel makes the most noise. Madam President, if I may just highlight one or two of the provisions of the bill that I think are...
Senator, 5 more minutes.
Much obliged, Madam President. Madam President, if I could just highlight one or two items, sections of the bill, the intent of which I think leads us to improving on the system. The Attorney General has already indicated the scheme contemplated by the initial hearing and the sufficiency hearing. And that, of course, is a provision in its substance that originates in the Parent Act. But what it does also, Madam President, is create timeframes within which the accused and the prosecution must do certain things. And this would bring some degree of monitoring and of dispatch to the procedure. Again, with masters of the criminal court empowered to treat with case management, that too will lead to an increase in the speed at which matters are progressed. And that cannot be dismissed as trivial or as inconsequential. Madam President, one of the other interesting and effective reforms is the provision that permits for electronic evidence to be admissible. And in this technological age, that is a very important step in leading to the gathering of evidence with respect to white-collar crime. And as the Attorney General has constantly repeated, the follow the money aspect of bringing white-collar criminals to justice. Madam President, the sections of the bill that improve the handling and recording of evidence, physical evidence, that is Section 5, again are to be observed as improving the system in which evidence is preserved. We have heard on too many occasions in the past, and the listening public is aware of it. The ratty ate the cocaine. The vehicle somehow that was stored outside of Besson Street has disappeared. It is no longer available as a critical item of evidence. So that is to be supported and to be encouraged. Again, a most important amendment is the amendment concerning alibi evidence of an accused and the time frames in which such evidence is to be given and the sanctions for failing to do so within sufficient time. But it also provides some degree of sufficiency for there to be alibi evidence referred to, provided sufficient time is afforded the prosecution to test the evidence, and that's Section 13B. The last provision I'd like to comment on...
Senator Simonette, your time has expired.
Madam President.
Senator Deyalsingh.
Thank you, Madam President, for giving me the opportunity to speak on the bill and act to amend the Administration of Justice Indictable Proceedings Act 2011, Act 20, number 20 of 2011. Madam President, there is no doubt that this act is very important in the proper runnings of the administration of justice. For far too much, we have heard of persons saying that they have instances where they have to go to court, they have to go magistrates court, high court, and it takes years. It's horrendous. And as the Attorney General actually pointed out some of the figures and the amount of cases that has to be, I think he had mentioned 43,109 cases outstanding for preliminary inquiries, and this delayed justice, this delay for the persons, the people out there, it actually causes a lot of frustration and for the individuals who have to get money, go to court from time to time, travel to courts, face the system, and it's really a way, I think, of the judicial system may be even sometimes re-traumatizing persons out there who have been traumatized by some sort of criminal event. And even victims of rape who, may have to go and face the court system and actually not get closure, but continue facing these individuals who perpetrated the act. It's really, really, unfair to some of our citizens. Persons, have to go to court for 10 years to get some sort of closure, some sort of justifications to this. And you have victims of crime, you have victims who are like, even the rapists, they suffer from post-traumatic stress disorder, where they actually may have instances where, they have flashbacks, they have these events, they are scared to go in certain places. They have instances where
Deyalsingh, will the senator with the offending device please leave the chamber, organize your device, and you can return in 5 minutes. Well, actually, you can return after the tea break, because 5 minutes will take us to the tea break. Senator Deyalsingh, continue.
Sure. Thank you, Madam President. As I was saying, the judicial system has been guilty of re-traumatizing some of these victims, because these victims will have to come in week after week, month after month, for years at a time, facing their perpetrators, or not even getting closure, facing persons who in their community may have done acts to them, and sometimes it's no fault of these individuals. This bill, if it hopes to somehow fast-track these matters, I think it is well needed. It is well needed for the victims that we have there, and it is well needed for victims of other crimes, because we even have cases where there's a victim support unit run by the police officers, and they are overwhelmed. They are understaffed. And they and all complain that when they have to see these victims and see them for all these prolonged periods, we are not getting closure. We are not getting these individuals to move on to their normal lives, if they would ever be able to move on, because some of them never do. 20 to 30% of people who are victims of crime do get post-traumatic stress disorder. And I think we have to develop a system whereby if we can implement this bill, we may be helping some of those individuals. Looking at, Madam President, looking at the case of backlogs, we look at the backlogs, a backlog of cases, and I wondered, how did it reach that situation? We looked at even court cases years ago. Most murder trials in their sizes would have taken, sometimes 2 weeks, and complex cases would have taken like a month. But now suddenly cases are taking longer. So there's a challenge. There's a challenge in the sense that you may have more case matter coming before the courts. You may also have, more complex matters sometimes may come before the courts. The laws keep changing. You may have cases where where there may be different reasons for the delay. Increased caseload, increased length of hearing, again, certain improvement in the cost management, certain new departments that the AG said he has put into place, like the Children's Court and Family, Children's Division, Criminal and Traffic Division, Criminal, all those are to be, all these are to be complemented. The criminal proceeding rules, all these can help. And all these, I'm saying, is very important. Those implementations, the AG must be praised for that. Also, these levels of staffing that has, that has come about, again, in terms of more judges, the appointment of masters, all these are areas where we have to look at the staff at higher level. And Senator Ramdeen mentioned his concern about sometimes the level of the masters. We have to be cautious of which persons or who persons we are putting into certain positions to ensure that we have persons there that would ensure that justice is done in a manner that no one can question it. In the past, we had cases where recently we had a case where a magistrate had a certain case with certain, a cocaine possession, and that case that, that magistrate had, the DPP got involved, and while I'm not going to name anything, the DPP got involved and actually had, the police officers were wondering why did that case go to the High Court? Why was it dismissed in the Magistrate Court and given, a small, some sentence where they are thinking it's such a case is such important that it should have gone to the High Court. So we may have cases where we may be suspect of certain things, we may look at certain things, and we have to look at the magistrates. Some of them may be appointed as masters. And if members may have concerns about the quality of the masters, I'm saying probably it's time we looked at the judicial officers and see, do we need to bring them into the Integrity Commission purview? This is something we may need to look at in the future. So looking at the fact that there is that delay that we are looking at the fact that the delays are there, we have to appreciate that the delay also, the backlog that we have.
Deyalsingh. Honourable Senators, at this juncture, we will suspend the sitting and we will return at 5 p.m.